Well, what people typically don't understand is when they have an injury case, it's not just about how much money do we get, how much do we settle the case for, or how much is our verdict, because there's also a large piece of that puzzle that's called lien reimbursement. Some call it subrogation, whether it's a federal program that's covered under what's called ERISA, E-R-I-S-A, or if it's a non-ERISA plan. But what people need to understand is, and this is troubling to me because a lot of people, of course, and I don't begrudge people, they try to represent themselves. There's a lot more to just getting to just maximizing their claim in terms of what do we settle this case for, even if a person would have what they would think is a clear policy limits case. And why do they need some lawyer? My own insurance company will surely take care of me. Well, that's usually not the case, but even if they did take care of you just for the sake of arguendo, once you get your settlement, it doesn't stop there. You just don't take the insurance check and stick it in your pocket. What you have to do is you have to look to see, well, what did my health insurance pay? Because many lawyers don't even understand subrogation or how to end up negotiating liens. How do you expect the average person to? So if you think you're saving money on the front end by not having to pay some lawyer 1/3 or whatever the arrangement might be, well then on the back end, before you put the first dollar in your pocket, then you need to worry about how do I pay back my health insurance. They just put me on notice. They sent me a questionnaire that I filled out. So even if you put the money in the bank, and even if you spend it, God forbid, that doesn't mean that they're not going to sue you. And good luck trying to get the same reduced number that someone like I can do. These contracts are nothing but the big print giveth and the small print taketh away. That's just the way it is. But I can tell you that in virtually all of these policies, there will be some type of a payback obligation, and some of the paragraphs or sections will even be entitled subrogation, and that tells you, the insured, what your obligations are. I have stories time and time again, whether it's a dismemberment case where there are huge medicals, if it's a Medicaid case, we have been successful in actually convincing Medicaid, in my state anyway, to accept literally a few dollars when the lien was tens of thousands. Medicare is that's a bit more interesting issue because of federal preemption laws. No one convinces Medicare to accept peanuts because the law is on their side. The law is not on the injured person's side. Even if it's an ERISA plan, we have been routinely successful in getting them to accept significantly less than what the lien is. And sometimes it works and sometimes it doesn't work. And then if you really feel that strongly and they're not doing the right thing as they should be doing, then you take it before a judge and you present your case, and they'll present theirs. I can tell you this, at least in my states, judges do not enjoy and they don't appreciate lien resolution cases coming before them to clutter up their docket when they've got plenty other things to do. So I have found that they're not too darn sympathetic with regard to the big companies that want to convince a judge that this profoundly injured person, should pay them back all of this money.